Good morning, everyone. Thank you for joining us today. I'm pleased to introduce Jeff Breinholt, who will be moderating today's event. Jeff recently retired from a long and distinguished career at the Department of Justice, where he was a key player in the government's response to 9/11. Today, Jeff is a senior research fellow at the program. Jeff, the floor is yours.
Thank you, John. And this is a very interesting and I would suggest timely topic, because the last few months we've been talking about the other side of terrorist financing. When I refer to the other side, I mean the non-criminal remedies. And as some of you who have followed our work know, there's a statute that is actually in the criminal code, but it's a civil statute, and it allows people, American citizens injured by international terrorism, to sue those people responsible. And if they are successful, they are entitled to treble damages and attorney's fees. This is referred to as the anti-terrorism, or the anti-terror, let's see, it's called HEA, the Anti-Terrorism Act, and it's at 18 USC 2333. Today we have three experts who are going to talk about the specific context of suing social media companies under the HEA. And just by way of background, the HEA was enacted in 1989, and for the first 17 years, I only noticed one case against one of the major high-tech social media companies premised on terrorism, premised on international terrorism, specifically providing communications to an FTO. And that all changed in 2016. And the interesting history is that the HEA, which I've referred to, was amended in 2016, and it was kind of a strange way, because President Obama used one of his 12 vetoes over his 8 years in office to veto the amendments to the HEA. And this was the only veto that was overridden by Congress. So it was called JASTA, and it created secondary liability for people responsible for international terrorism. So banks, multinational companies, and significantly for our purposes, social media companies started to be sued by victims of terrorism. This was back in 2016. And it was very controversial, because most people, I think, most plaintiffs' lawyers were discouraged from going after social media companies in a civil cause of action because of this defense, or this immunity, that was built into the Communications Decency Act, specifically Section 230, which basically was a effort to grow our social media industry in the United States. And they created some pretty wide immunity that basically gave the social media companies a safe harbor if they are simply posting the messages of other people. They were considered to be immune from the typical publisher liability. And so there were several, I'd say about 6 or 7 cases against Twitter, Google, Facebook, and others, mainly on the West Coast. And people like us were excited when in 2022, the Supreme Court decided to take a consolidated appeal of a group of lawsuits against social media companies, specifically for facilitating terrorism. And that case, there were 2 cases that the Supreme Court heard simultaneously. One was Gonzalez v. Google, and the other was Twitter versus Tomney. And so people like us who believed that there was a lot of problems with the social media industry thought that this might be an opportunity for the court to provide clarity on the Section 230 immunity. And we're going to find out what happened in 2023 from our panel today. There was a series of questions that we were holding our breath on, and it turns out that the Supreme Court largely dodged the issue. We have a very distinguished panel, and by the way, there's a lot of talk now about the ill effects of social media company activity. And we're not going to be talking about that in as much as we're talking about specifically suing social media companies for terrorism under the ATA. And so we're going to start with Katie Paul, who is the executive director of the Tech Transparency Project. And she is going to give us a real taste in the next 15 minutes. She's going to give us a real taste for what the phenomenon is. If you're a doubter and you don't believe that the social media companies are in bed with the terrorist infrastructure, she is going to disabuse you of that through some real examples. So first we'll hear from Katie. Then we'll hear from Professor Will Mackie, who is a former colleague of mine at DOJ, a longtime colleague, and he's now an adjunct professor of law at Washington and Lee, and he keeps up very closely with the Supreme Court jurisprudence. And so he'll give us a sense of what happened in Tomney and what it portends for the future. And then finally, we'll hear from Annie Kouba, who is a senior associate at Motley Rice and is the lead counsel on a current case in Northern California, a multi-district case in Northern California involving social media companies. And she's going to give us a perspective of the practitioner, what Tomney means to the people like Annie who pursue claims on behalf of victims. So with that, let me turn it over to Katie. Katie, you're muted.
All right, there we go. Thank you so much. So like many people in DC, I wear many hats, but for this, I'll be reviewing examples from two aspects of my work, tech and antiquities trafficking. And we're going to start with tech from the Tech Transparency Project, which is, and for those who aren't familiar, TTP is an information and research hub for journalists, academics, and policymakers, and members of the public. Basically, we want to give the public a seat at the table for the tech that dominates our everyday lives. So we all know that there is bad content online, and big tech companies often argue they're simply a mirror to society. And TTP's research shows how these platforms are dangerous by design and amplifying extremism and profiting in the process. We have some really good legal experts that will discuss the elements of the Gonzalez v. Google case in depth, but there are some pieces I think that are important to set the stage for the findings that I'm going to discuss. For those unfamiliar with the case, obviously, the Supreme Court dismissed the claims from victims of a 2015 Islamic State attack that basically claimed that YouTube violated the Anti-Terrorism Act's material support clause by algorithmically amplifying ISIS content. It's one of many cases that have been brought against these tech companies, and the court's decision essentially also included that the claims did not meet the threshold for material support, including the stipulation that the company did not knowingly provide substantial subsistence. At the time, it was new that big tech was being utilized, social media was being utilized by terrorist groups in that way. So in 2015, it's possible that the companies may not have knowingly been used for these purposes, but it's been nearly a decade since 2015, and the companies are very well aware of that. But before we dive into the intricacies of the ATA, I want to also look at how tech platforms may violate the ATA and other laws independent of Section 230 and ways that Section 230 may not apply. So one of those is X. In February, the Tech Transparency Project found that X appeared to actually be violating US sanctions law by selling its new blue checkmark premium subscription services to entities and individuals listed in Treasury's Office of Foreign Assets Control's database, including multiple terrorist groups. In April 2023, some of you may be aware that X began offering its blue checkmarks, which were once a free tool used to legitimize accounts. Now it's a paid service with special features, meaning that anyone you see with a blue check mark that still has it as of April of last year is paying for that check mark. The premium perks that come with the service include algorithmic priority for content, the ability to write much longer posts without a character limit, live stream videos, the list goes on. But in some cases, these accounts were also eligible for revenue sharing, which means that any ads shown in replies to their posts, X may have also been not just profiting, but also financing terrorist groups through this revenue sharing process. So when it comes to sanctions, whether or not a company was aware of the activity, as the case with the ATA, won't apply here. A violation via financial or service transaction is a violation of the law, whether it's $1 or $1 million. But there's evidence that X knew it was engaging with terrorists while selling the subscriptions. So take, for instance, this account that was identified by TTP and claimed to belong to Hassan Nasrallah, the leader of Hezbollah. The account received its blue check subscription in November 2023. That was the same month that Nasrallah threatened further escalation in Israel's war with Hamas. The account posts featured ads in the reply section, as I mentioned, you'll see here on the right, meaning that it may have also been receiving a share of that ad revenue, but that is not all. The account also utilized the premium feature of ID verification. For that ID verification badge, users must send X a selfie as well as a copy of a government ID to prove they are who they claim to be and that they're a real person. That means that either the user behind the Nasrallah account is not operating for Nasrallah and the premium ID verification service is false advertising from X, or that X knowingly profited from an account it knew belonged to the leader of a terrorist group. And his selfie and government ID are floating somewhere around X services. Notably, the company that does X's ID verification, which is called Authentics, is an Israeli company. So it's unlikely that that company did not know who Hassan Nasrallah was. TTP found premium subscription accounts for other Hezbollah members like Naim Qassem, the deputy to Hassan Nasrallah, Hezbollah media outlets, Houthi leaders, and even the official Ansar Allah Houthi account, which was linked directly through the Houthi website. The removal of the blue check in some cases and the entire account in others from these terrorist groups led to even more evidence that social media platforms are critical telecommunications infrastructure for terrorist groups. So for instance, after Ansar Allah lost its blue check account that was linked through its website following our report, the terrorist group put out an official statement on its Telegram and its website, calling the removal of its blue check mark a human rights violation. This is the first time that a specially designated terrorist group has issued a formal statement regarding the removal of an account from a social media platform. And the fact that such a statement was issued in the middle of a devastating conflict also highlights the importance of social media to that group's telecommunications operations. But it wasn't just the Ansar Allah accounts. They weren't the only ones lamenting the removal of sanctioned perks. Shortly after the blue check mark disappeared from the Nasrallah account, the account tweeted, Does anyone know why the subscriptions were canceled? It's very annoying when the amount of words required to express your thoughts are limited to a number. It's very clear this account was paying for the blue check to be able to have more extensive discussions on propaganda. And the account has since set up another account with a blue check premium subscription and directed its users to that new account so that it can post longer form messages and longer Hezbollah propaganda videos. But tech companies are also amplifying terrorist content, not profiting from them. Obviously, it's not new. Nearly a decade ago, ISIS was really making savvy use of social media platforms to spread its extremist messaging and recruit members. But they still rely on Facebook, as many other terrorist groups do, to amplify their propaganda. And today, as Meta and social media companies are continuing to struggle with keeping terrorist groups, Section 230 doesn't immunize companies from their requirements to adhere to U.S. sanctions law, nor does it protect companies from content that is not created by third parties. So what about the content created by platforms themselves? For years, Facebook has actually helped bolster terrorist group reach by automatically generating hundreds of business and location pages for terrorist groups like the Islamic State, Hezbollah, Hamas, and the IRGC. The content created is created by Facebook itself. And as you'll see here on the left, these auto-generated pages can serve as a gathering point for extremists to connect and broadcast their ideology to Facebook's billions of users. Facebook auto-generates business pages on its platform when a user lists a job or location in their profile that doesn't have an existing page. Facebook hasn't explained a reason for these auto-generated pages. Notably, a help page about the feature that was deleted sometime after January 2020 by Facebook explained that a page may exist for your business even if someone didn't create it. For example, if someone checks into a place that doesn't have a page, an unmanaged page is created to represent that location. Facebook has known since at least 2019 that it was creating business pages for terrorist groups. In May 2019, an SEC whistleblower filing raised the issue of Facebook's creation of pages for terrorist groups and extremists, and the company's top brass have known since then as well. Facebook executives, including CEO Mark Zuckerberg, have been asked about the creation of pages for extremists in 3 different congressional hearings on 3 separate occasions. We have clips of each of those in one of the articles on our website that was covering the auto-generated pages. But today, Facebook is continuing to knowingly create business pages for terrorist groups. This is just a preview from some data for an upcoming TTP report. We've identified hundreds of auto-generated pages for terrorist groups, including dozens for Hamas, Al-Qassam brigades, Palestine Islamic Jihad, and Al-Aqsa Martyr brigades, all entities involved in the October 7th attack on Israel. All of these pages that we identified for these groups were created after the October 7th attack. The findings are not only undercutting many of Facebook's own claims about how it's been addressing terrorism since the attack, but also show the platform is materially contributing to growing the digital footprint of these groups. Facebook's knowledge of the issue is notable. In 2023, when the case was dismissed for the Gonzalez v. Google case, the ATA support clause about whether or not the platform was knowingly engaging in material support seemed to be something that the court really hinged on. So by auto-generating these pages, Facebook is actively creating content for extremist organizations that are involved in real-world violence. The pages increase the group's visibility and legitimacy on the world's largest social network. And the important distinction here is that Facebook, not third-party users, are creating these pages. They are the publisher. And with the protections afforded by Section 230, those protections do not apply to publishers. But problems like the auto-generated pages issue are no longer shocking claims about the platforms. I'm sure we'll hear more about all of the different harms and ill-gotten profits from the activity of these tech companies. But now the big tech companies are knowingly engaging in this activity, so it should be no surprise that trafficking, war crimes, and terrorism are also on the table. So my background investigating tech actually started with the investigation of the terror finance of antiquities in trafficking and antiquities and war crimes. And in 2018, I launched a research project with my colleague, Dr. Amar Al-Azam, that monitors the documents trafficked antiquities on social media platforms, primarily Facebook. After we published our first report on the issue in 2019, highlighting Facebook's role in the illicit trade and their lack of a policy on the illicit trade that is funding terrorism, the company did create a policy banning the sale of artifacts, but it largely exists on paper, and like many other policies, it's not enforced. The trafficking of artifacts from regions in conflict is a war crime under the 1954 Hague Convention. And this is not just a matter of war crimes evidence, but also terror finance being posted on Facebook. The company is a major facilitator in this particular war crime and is taking an active role in the crime. It is the vehicle for this war crime. From Syria to Iraq to Libya, and Afghanistan, Facebook remains one of the largest digital black markets for blood antiquities. And this isn't simply a matter of trafficked artifacts, it's also an issue of funding extremism and conflict. Traffickers from extremist groups like ISIS and the Taliban continue to utilize Facebook to this day to help finance their activities. And these groups operate with impunity on Facebook, in some cases, even using antiquities trafficking groups to traffic US and Chinese-made unexploded grenades following the US withdrawal from Afghanistan. Again, this is trade that is only possible at this scale because of Facebook's failure to address it, and Facebook is the vehicle for this particular crime. The evidence is clear that despite the Supreme Court decision and the role of companies knowingly engaging in material support for terrorists, these companies are violating laws where Section 230 may not even apply. In 2015, it may well be true that until then, until media and researchers had raised the issue, YouTube and other tech companies didn't technically know how their platforms were used to amplify terrorist content. But it's been nearly 10 years since the attack that case hinged on, and companies are not only well aware that their tools are amplifying content, they've continued to profit and increase algorithmic amplification without effectively addressing that content on their platforms. I look forward to the thoughts from the lawyers on the panel on some of these issues.
Okay. All right. Thanks, Katie. And one thing I'll point out about Katie, which is interesting, is she is an anthropologist by training. She has her master's degree in anthropology, which you sometimes see in this field, but not too often. Let's go to Will Mackie, who is going to tell us about the two cases that the Supreme Court considered last term. You're muted, Will. There you go.
Yes, thank you. And thank the GW program on extremism and Mr. Breinholt for inviting me here. And I think Ms. Paul put this in really great perspective for us. And I think what we have to think about in this context is we're dealing with the 21st century reality of this rapidly evolving technology. Now we're going from internet to artificial intelligence and there on out, essentially working with 20th century law. And, we don't have a 16-bit 286 computer anymore, but we certainly have Section 230, which was passed in 1996. So the question is, do the tools that we have now be able to address the problems that Ms. Paul was talking about? And essentially, what are we dealing with? We're dealing with the internet now that has vastly expanded. It's a vast, extensive space that has extreme influence on people. And is essentially, quite frankly, it's unregulated. It is a self-regulated industry. And that's what the law is. That's the way it is right now. And that's the reality of it. And the fact that extremist groups, domestic, international, from anybody up to ISIS and onward, take full advantage of point number one, right? And they use these platforms to advance their interests, to facilitate their mission, to recruit, to do everything we're talking about. No question about that. And we are faced as a public policy and a legal question is, shouldn't there be a law about this? You know, is there something that exists out there, right? And the difference between the law that exists for material support for terrorism, which is where somebody is actually taking an affirmative act to create money to support terrorism. There's a law for that. But here what we're dealing with is the use of platforms, right? Social media platforms, a provider, internet provider. We use different terminology, and when we talk about the Section 230 of the Communication Decency Act, Congress specifically carved out basically information, basically providers, we'll just call it that, distinguishing them from newspapers who have editorial control and all. And the Supreme Court essentially, as we're going to talk about these cases in just a moment, the Supreme Court essentially said, wow, look what's out there. There's billions uploaded all the time. There's no front end checking on this thing. So we're going to hold basically internet providers in a different category from, in a sense, publishers. And we'll talk about Section 230 in a moment. But essentially, I find this really fascinating, this topic and these cases, because it is this intersection of national security law, right? There's criminal statutes against international terrorism. There's criminal law aiding and abetting, right? 18 U.S.C. Section 2, which greatly influences the civil tort law aiding and abetting, which we were talking about, 2333, particularly a primary liability, right? You can sue ISIS, good luck with that, but right, you can sue them the primary liability, or 2333 D2 is secondary intermediate liability. Somebody else helped them, aiding and assisting. And the terminology is, in a sense, substantial assistance. And as Mr. Breinholt talked, initially, the Anti-Terrorism Act had just a primary liability. And the courts clearly said, can't sue somebody for secondary liability, doesn't exist. Then the Joint Justice Against Sponsoring Terrorism Act, JASTA, in 2016, as Mr. Breinholt said, was passed specifically to address that problem and gave secondary liability. So somebody else that substantially assists the primary in the as a tortfeasor, that you can sue them for remedies because you're aiding and assisting. And what that means, we'll discuss in a moment. Then, of course, we got cyber law. So we got national security law, criminal law, civil tort law, and cyber law, such as it exists, particularly talking about Section 230 of the Communication Decency Act. And then, of course, overall, we're talking about internet policy, public policy. All right, so the two cases that this really all came together in was, as you said, Twitter versus Tomney and Gonzalez versus Google. So Twitter, as we know, Twitter now X, whatever, is a social media platform that communicates things. Google operates YouTube, and thus we all know about the ISIS beheading videos or anything, it's up there. So basically the victims of terrorist acts, and these were acts of terrorism, attacks in terms of on nightclubs and places in Paris and in Turkey, tried to use this law, 2333 D2, to hold secondary liability for the platforms that disseminated this information. Now, interestingly enough, in the Twitter versus Tamney case, it was focused almost solely on the issue of whether or not under 2333 that the platform, the provider, aided and assisted, substantially assisted by allowing their platform, such as it was, to be used, right? Whether that raised to the level of aiding and assisting. And Gonzalez versus Google / YouTube, it was both 2333 talking about aiding and assisting, but also raised the issue of whether or not Section 230 prohibited that type of action. Reason being, what Section 230 says is that an internet provider, right, cannot be held civilly liable for any action that's a third party takes in posting content on their platform. All right. So you think about the issue of publisher liability, like a newspaper. It's like, doesn't exist for an internet provider if they're not responsible for the content. And that's where it really comes down. Remember, primary liability, secondary liability. The person who writes the item, creates it, has, in a sense, under Section 230, we can call it like primary liability. And the internet provider does not have secondary liability under Section 230, because unless they have a hand in creating that content, all right, they are not. It's a carve out, right? And the courts and opinions will say, you know, otherwise, like defamation, they're definitely a publisher and they should be liable. But there's a carve out on this thing. Now, as Ms. Paul was talking about, and we're going to get into, is the issue of, in a sense, algorithms, right? And algorithms are basically defined as a set of rules or signals within a particular program that generates a collection of existing content that is then provided onward to somebody who indicates they're interested in it. All right. Now, I'm going to hold off for a moment on the auto-generated pages because it's a very interesting question. But the issue there is that the Supreme Court in the Twitter and the Google case, right, Tom Mayer Gonzalez, basically looked at this case in terms of three things. They said, all right, so the plaintiffs basically said that the internet providers operated a platform that was used by terrorists. No question about that. All right. Not a question about that. That the algorithms that were used would have an effect of collecting data content and providing it, sending it on to people that they thought automatically were interested in it, right? Just like when you Google something with dog toys and you get all these dog toys ads, that's an algorithm, right? So if it happens to be a terrorist issue, they're putting it together and sending it on. And then third point is taking on from criminal law to civil tort law, which is essentially, you know about something, it's going bad, it's on your platform, and you didn't do anything about it. Right? Are you liable for that? And in essence, the law stands as Kouba can talk about that, you know, you can sit by and see something really terrible happening, somebody dumping chemicals into the river, and you don't do anything about it. You may have some moral responsibility, but you really don't have legal responsibility. And so the courts look at, and the Supreme Court was looking at this and saying, these are the issues. Did operating the platform, having the algorithms, and not doing something about it, even if they knew it's out there, did that constitute in some manner aiding and assisting of substantial assistance for the liability under 2333 D2? And then the secondary issue in Gonzalez was whether Section 230 barred this altogether. So the gist of which is that the Supreme Court said, you know what? Platforms operate for everybody. There is no front checking on this thing. So it is a different type of fish. Right. So it's not like newspapers, not like anything else. So the fact that they are using this, ISIS, whoever is using this, is no different than anyone else that uses this. Everyone can upload. There is no front check on this. So that the fact that they use this means the messenger shouldn't be held secondary liable. Right. That the primary person did it. There's no content or anything. That's the Section 230 concept. But the aiding and assisting is they didn't take a conscious, culpable act to help somebody else. All right. The fact of using their platform like anyone else did not rise to that. That's what the Supreme Court said. Algorithms. The question was, they said it's essentially agnostic. It's neutral. Everybody that it's an algorithm, whether it's shoes or hamsters or terrorism, it operates the same way. So therefore, you are not engaging in some affirmative act to help. And that's where, in a sense, they said in terms of the 2333 aiding and assisting, it did not constitute substantial assistance. And then lastly, the third point about they knew about it and didn't do anything about it, that nonfeasance, as in did not do anything, does not constitute aiding and assisting. All right. Should they maybe have done something? Perhaps, but they didn't. But that doesn't hold them legally responsible. So let's talk about, in a few minutes I have right now, is the Section 230 issue. All right. So what that means would be, under the same theory, which was, are the social media platforms immune from the fact that immune from any civil tort liability for the fact that people are using their platforms, ISIS, terrorists, extremists, in the manner that we're talking about? And essentially, the Supreme Court did not reach that issue, right? In Gonzalez, that was raised at the Ninth District Court and the Ninth Circuit Court, right? And interestingly enough, in the Twitter versus Tame, it was not raised. So interesting, they combined the two cases, right? And it made it look like they were going to talk about Section 230, right? But they didn't, because in both of those cases, they said there was no civil liability for aiding and assisting. Thus, we don't have to go to the Section 230 because there's no liability, right? So that was the way that, it's not like they kicked the can. They basically said, you have to have liability of some sort for Section 230 to kick in. So no liability, so we don't have to reach this issue. I would suggest, however, that the Supreme Court opened a little bit of the door for this, right? And I think they looked at this and said, in terms of aiding and assisting, they said, if the platform program in some manner specifically helps or specifically advances this, this primary liability, right? Not just like they do it for everybody, but do something substantially different, then possibly you could have aiding and assisting. That's under this 2333. I would suggest that's the same concept, which in a sense Ms. Paul was talking about. If you have particularly driven algorithms that create something, right? Because under Section 230, if you're a publisher, only if you are involved in creating something. So what the primary liability is the creator, right? That's the information content provider, the person who writes the stuff. It gets loaded on the program. The social media piece said, I didn't do anything. Section 230 allows them to take it off without liability, and or allows them to do nothing without liability. But if they change it, right, they become a creator, and then they have liability. So that's the issue here. So essentially, the Supreme Court looked at this and basically said they didn't do anything that transforms them from in their secondary liability of substantially assisting terrorism. And I suggest that's the same theory that would apply as saying, okay, you're not an information content creator just because you put that in there. What is left open, I suggest, would be if they go on to the point where they're generating pages, as Ms. Paul was talking about, creating content, possibly that could be something that takes them out of the protection of, Section 230. That essentially what you have to look at as is to say that Section 230 says a internet provider who organizes, reorganizes, or translate content is not liable. They're just gathering stuff together that exists and putting it out. But if they start in some way creating something that wasn't there before, then I think you have Section 230. Question as to whether the liability applies. So let me end with this. 230, status quo, reform, or eliminate is the debate, all right? And we're talking status quo is self-regulation. Reform, I think eliminate's not going to happen, but I think the reform could come in a couple ways. I think you could have carve-outs for bad Samaritans, as in people who are using it specifically to advance a bad purpose, and certain carve-outs for child exploitation, terrorism, cyber stalking. Put that in there and say these specific things do not allow you to immunity to do this. And then the last thing I'll leave it on was the concept of notice-based liability. Right? If somebody says to Google or whatever, hey, this stuff is on here and you're doing it, then that's an issue whether or not under the current law, notice-based liability doesn't exist for under Section 230. But that may be something where you say, here's a carve out that if you're specifically known that your platform is being used for bad purposes and you do nothing about it, that similar to copyright law, you do have a duty to do something. So anyway, I'll close it at that I do think that Section 230 needs to be changed.
Okay, before turning it over to Annie Kouba, let me ask both Katie Paul and Will Mackie, do you guys think that some reform of 230 and the ability, maybe the way Will described it, it would be an exception to 230 or a series of exceptions, would the prospect of civil liability cause the big high-tech companies to clean up their content? Do you think is that a link that we're willing to make at this point?
I think for that, we can look at existing situations where how companies have dealt with situations where there is a current carve out, which is the FOSTA-SESTA carve out with regard to sex trafficking, that does open the companies up to civil liability. That was part of the Backpage.com case. It was signed into law in 2019. The tech companies fought very hard against that bill, but it was passed with bipartisan support. There is a case, I believe lawyers Annie McAdams in Texas, for a Jane Doe that was sex trafficked through Facebook. After Facebook has fought tooth and nail for that, it took years to even get to the threshold where the case will be heard in court. But that is one example. I think the fight that Facebook put up to keep that case from even being heard is an example of how they know that civil liability could really open the door and start the tumble of things. That said, it's been years now and the hearing still hasn't happened. They're still fighting, and the amount that they're pouring into cases like that are important when it comes to trying to understand that they know that they're liable. One interesting question would be if they actually just invested in people to address some of these harms, wouldn't that probably be cheaper than the money they're pouring into combating these lawsuits? That's a different question, I think. But, those kind of carve outs, Section 230 carve outs, a lot of experts have said, if there's a carve out for sex trafficking, why not other harmful crimes? Why not opioid trafficking? I think Joe Manchin had floated that a few years ago. And the question is, should these companies should this be an issue at all? I think the Bank Secrecy Act is a good example of when an industry really pushed against something, saying it was impossible for them to monitor that. And lo and behold, they can if they have to.
Well,
Okay.
I mean, I think that the civil liability, as Kouba is going to talk about, is is there because it's a self-regulated industry, because there is no regulation. All right. So I think that's the bigger problem. All right. We don't have an EPA or FAA or anything relating to the internet. Right. There is really the FTC at best tries to squeeze in a 1905 law to regulate the internet. So civil liability, in a sense, is the only way. Now, from the providers, they said, look what the Supreme Court says: billions of upload every day. How are we possibly conceivably able to manage this thing, as opposed to the Bank Secrecy Act? If I was arguing on that, it's like, hey, we're a bank and we have certainly money deposits and transactions. That's a manageable set of data. This is not. All right. And that's why it's going to be very hard. And I think carve outs combined with notice liability may be something where you say, hey, look at, we're not saying you have to look at a billion things. How are you going to hire enough people to do this? But hey, maybe with AI intelligence and this sort of stuff and notice based, you can have some, at least a measure to try to deal with this. But that 230 as it stands right now, it does not allow for that. And that's why I think it needs to be reformed.
Okay, thank you. Annie Kouba, let's hear from the plaintiff's practitioner.
Hello, everyone, and thank you again to Mr. Breinholt and the program on extremism for having me here today. And thank you to my fellow panelists, Ms. Paul and Mr. Mackie. It was fascinating hearing your perspectives, being in the position that I am going to be talking about all of these issues coming together today. Mr. Mackie stole my line right at the very end there, saying that civil liability becomes even more important when an industry is so unregulated. I'm of the view as a plaintiff's trial attorney that all of our litigation that we take on and believe in should be with the intent to change corporate behavior, to keep them in line with the law. Money is what motivates these companies at the end of the day. It's what keeps them on good terms with their shareholders, and it's what keeps them in business, and it is a powerful motivator to change corporate behavior. That said, that importance is heightened when there is essentially no other oversight happening of these companies. And I'll start back at the beginning from what Mr. Breinholt and Mr. Mackie both mentioned on JASTA. I won't repeat it too much, but I think that there's an interesting parallel here that in 2016, we were at a very highly polarized time politically in the nation, and it was so universally agreed upon by Congress in both sides of the aisle that not only did it pass through both chambers, but it also had enough of a majority to override President Obama's veto. To me, that's important in the relevance here today, because Section 230 is undergoing a similar discussion in Congress. There may not be exact consensus on how 230 needs to be reformed or even eliminated. The opinions of our representatives vary on that, but if you were able to watch any of the congressional hearings on child safety that involved multiple social media companies, every politician felt the need to note that this was a bipartisan effort, that Section 230 reform was necessary, that they wanted to move forward together one way or another. Seeing Lindsey Graham and Elizabeth Warren agree on a topic is near miraculous. And I think that goes to the importance and the tandem importance of these two statutes at issue here today. So going back to JASTA, we've touched on this briefly, but I think that it can be easy to get a little too distracted by Section 230 in the civil liability context for holding terrorist activity or holding corporations liable secondarily for terrorist activity. As you could see from the Supreme Court's decision in Tamnay, it's the part that you have to prove first has not really changed. Of course, it could be argued that that decision slightly narrowed the factors used to address or determine secondary liability and when it attaches, what sort of actions need to be taken. But the Supreme Court did not wholesale say that the behaviors engaged in by defendants would never be successful in bringing a secondary liability claim. And really what they said was in assessing the factors that are necessary to determine whether an action rises to the level of substantially contributing or substantially contributing through aiding and abetting behavior, terrorist activity, that's really where the analysis turned. As Ms. Paul pointed out, the knowledge defense used to be a much stronger defense for these types of defendants. You know, how could they possibly know? Billions of posts out there. That's really not what the court turned on in Tamnay. They were looking, they acknowledged that plaintiffs had satisfied the first two factors that require that they know that a terrorist act had occurred and that there was knowledge that those terrorists were on their platform. What it really came down to was whether they knowingly provided substantial assistance. And what does substantial assistance mean? So I will get to Section 230 because I'm not saying it would be irrelevant, but nothing about my practice area, in particular in the anti-terrorism and human rights field at my firm, has necessarily significantly changed. And I think for both of these statutes that we're discussing here today, the ATA and Section 230, for a civil attorney practicing in a day-to-day practical sense, the important thing to remember is the pleadings must be pled very carefully. And I don't mean in any way, of course, that it would be, adding in facts that are not existing, nothing like that, but just the way that you're phrasing is going to matter here more than in almost any other pleading of a complaint that is typically just factual in nature, and you may not have to think about the specific word choice you're using quite as much. But for both of these cases, that's going to become increasingly important because without, my personal opinion on how Tamnay and Gonzalez were pled, that's essentially where their cases were lost at the end of the day, was that the court took the view that the pleadings would have required the corporations to be responsible for every terrorist act carried out by ISIS due to the lack of specificity connected to the attack that happened in Paris, for instance, or at the Rana nightclub. So with that said, a specific knowledge is not required to hold a corporation liable under the ATA. They simply need to generally know that they are substantially contributing to terrorist activity. That is not an unfettered general knowledge, however, when it comes down to the pleadings of specific terrorist acts that you are relating back to the corporation's actions. The same is true for Section 230 on the way that you plead these actions. So as Mr. Breinholt mentioned, my firm, and specifically Previn Warren at my firm, a member here, was appointed co-lead counsel in the social media MDL that's currently ongoing in the Northern District of California. That entire team was very closely watching the court's decision in Gonzalez because that was a highly anticipated decision in the Section 230 world. On both sides, that was one that was being watched with bated breath. As you all know now, the court didn't reach that issue, which is why I started with the ATA and the importance of making sure that the pleadings are specific enough to support that claim, because the affirmative defense of Section 230, which is essentially what it is at the end of the day, is an affirmative defense, a shelter statute essentially, is not going to come into play at all if you can't prove the foundational tenets of secondary liability under the Anti-Terrorism Act. However, if you do get there, I'm of the view that even though they may seem like they could be in conflict, or they may seem like that Section 230 could provide a safe harbor, that in the vast majority of secondary liability cases under the ATA in the civil context, if you've met the burden of showing that there is substantial contribution to terrorist activity there, and that it was knowing, and you've already passed the factors required for secondary liability under the ATA, it's highly unlikely that Section 230 will bar those claims. And I think there's been a bit of fear surrounding how 230 would apply to these types of cases, justifiably so, because the law is fairly unsettled. But even today, with no reform, which I agree with my colleagues, there does need to be some sort of reform to Section 230, in my opinion. But even without reform to Section 230, the way that it is set up, it is protecting corporations from secondary liability. That's what I'm saying. It seems like there could be some real tension there if you're proving secondary liability under the ATA. But the key difference here is that if you've got the facts to show that there was substantial contribution to a terrorist activity, you've almost already assured that the platform was not acting as a mere publisher. And what I mean by that is if they were acting as a mere publisher, which is the only way that they can have protection, that is, your claim is focused entirely on the content that a third party posted, and the corporation or platform had nothing to do with its creation besides shepherding it to the outside world, then they would be protected by Section 230. But if you've already proven that they took enough steps to tie to a specific terrorist activity, or to tie to a specific terrorist group, or to show that they're nonfeasance, which is not completely barred by the Supreme Court's ruling, at least in my interpretation under Tamnay, it simply is a higher burden to prove. If you don't have that malfeasance affirmative action, a nonfeasance claim needs to be supported by a higher amount of knowledge, a stronger showing of the other factors that the court uses to go through and decide what rises to the level of secondary liability. It's a trickier path. So I think if you can plead affirmative facts, that's the safer route to go. But if you've done that, you've essentially assured yourself that it's not going to be a mere publication of third-party content, especially because in tort law, unlike in conspiracy law for criminal law, there has to have already been an actual injury, an actual tort that was committed to show secondary liability. So that takes us out of the realm of third-party content, which may be illegal in and of itself and may be tortious in and of itself, but is unlikely to be the type of tort that falls into the Anti-Terrorism Act statutory regime. So you're already bringing it through a terrorist act that has occurred. Another consideration for Section 230 immunity is whether the act in question is about content. It's okay if it's the but-for cause of another tortious act, but it cannot be about the content itself. In responding to the motion to dismiss in the In Re social media litigation, one thing that we tried to make clear as a theme in our brief, that these cases are about conduct, not content. And if that mantra is kept in your head for any civil litigation that potentially conferring civil liability onto a platform that may otherwise be protected by Section 230, then you'll likely be in good shape, because it is about the conduct that the platform affirmatively takes to remove itself from that safe harbor. So the reason I bring up the MDL again, despite the fact that, as Mr. Breinholt said here at the beginning, there are a wide variety of harms caused by social media, and we're here to talk about terrorism, the law can be instructive on the way we plead terrorism allegations. For instance, defendants did lean very heavily on their affirmative defenses of Section 230 immunity and First Amendment immunity, First Amendment rights when these claims were first brought against them. A very quick, broad overview of these claims are that plaintiffs are alleging that various social media companies have acted under essentially a product liability frameworks that most attorneys are very familiar with, a failure to warn negligence framework, and caused or contributed to causing young people's mental health issues, which also have sometimes gone so far as to cause death, whether that's death by suicide, severe eating disorders. So the harms are wide-ranging there, but the framework is not dissimilar from any other product liability case, except running into 230 in that action can get a little bit trickier. Are you alleging that the actual content that the children or young adults viewed is the harm? Or are you alleging that the actions of the corporation, whether malfeasance or nonfeasance, are what caused the harm to the child through a proximate cause framework? We, of course, argued the latter and argued that it was not about content at all, but about the conduct of the companies. Judge Gonzalez-Rogers ended up ruling in our favor on most points in her motion to dismiss opinion. She did find, like some other courts, that this unsettled issue of what an algorithm exactly qualifies for is likely protected under Section 230, but she found various other features of the product, including insufficient parental notification or parental control features, insufficient age gating, which keeps children under the age of 13 or should off of the platforms, making it more difficult to delete the application. These sorts of features of the applications she upheld as not being protected by Section 230 because they are not publication of content. So that's another consideration in a terrorism case when you're moving forward. The easiest example, because it is frighteningly common, is the videos on YouTube or the posts on Facebook, Instagram, Snapchat, whatever it may be, that are content-based and are inciting terrorist activity. Those, as we have seen, can be a little bit trickier to get to secondary liability under the ATA, much less to get through Section 230. But if you look at it in that more traditional setting of some of the examples Ms. Paul showed of creating these pages themselves, of facilitating transactions, either in money or antiquities, looking for potential claims that do not relate directly to third-party content, is certainly an area that you should explore further, and in my opinion, in the civil plaintiff's world here, when you're looking to hold a platform liable without invoking the wrath of Section 230. So I want to be clear too that the conduct, not content distinction is important, but just because an allegation involves third-party content, that's also not prohibitive under Section 230. There's a case that comes to mind that ended up hinging actually on promissory estoppel. This was a Ninth Circuit case where a plaintiff asked Yahoo to remove an explicit content that was posted about her by a third party, by an ex. And the court found in that case that Yahoo's failure to remove the content would be barred by Section 230. But because the plaintiff had gone to Yahoo and asked, and Yahoo assured her that it would be taken down, that gave her a path forward because that's not undertaken in their act as a publisher. So drawing these distinctions will just be important for plaintiffs' attorneys to keep in mind as they are drawing up their pleadings, both for liability under the ATA and because it will only help you become stronger to get past Section 230. And unfortunately, I could keep talking about this issue for quite a while, but I have not kept my eye closely on the time. I think it's probably up. Is that right?
You're okay. We're going to go to audience questions in a minute, and we only have one so far. So go ahead.
All right. Well, to go back to the reform of Section 230, I think it's important to think about its beginnings. It is a very humble law. I don't think that at the time it was enacted, the legislators could have possibly envisioned the kind of sweeping immunity that defendants over the years have used it for. It is, at its essence, a municipal law that was intended to, as we've discussed, relate specifically to defamation and to protect companies from being held liable for defamatory statements that they did not contribute to, that they did not edit or draft themselves. The expansion of Section 230 immunity to apply this way, frankly, doesn't make much sense in our current landscape of the way internet service providers interact with others, conduct their business, earn their money. It's my contention that Section 230 was never intended to reach that far, because how could someone in the late 90s ever imagine what the internet would look like today and what our social media landscape would look like today? There's been a lot of talk about that social media companies can't possibly monitor every post billions of posts are going up a day. The content is all over the place. But, you know, the fact is that they are already doing this through machine learning, through other developments in technology that they have developed. In fact, they're already screening, or should be, for content that violates their policies. You know, that is something that if you go on Instagram, sexually explicit material is flagged and usually pretty quickly taken down. Of course, there's exceptions to this because it is often machine learning based, but the problem of they couldn't possibly be looking at all this content doesn't really exist in that format anymore. And so I think that the time has come for Congress to reconsider how wide-reaching Section 230 is, and agree with my colleagues that certain carve-outs are certainly appropriate. Coming from the civil liability standpoint, I think even a carve-in for a private right of action could be appropriate. It's worth the debate and discussion, but I think staying at the status quo, it is not going to impact ATA cases as strongly, in my opinion, as we once feared. Of course, reasonable minds could differ on this because Section 230 is a fairly unsettled area of the law, and because both statutes require highly fact-based pleadings and can turn on very small nuances in both technology and in the law and in interpretation of factors and in what substantial means. So I'll be very interested to watch this space and see how it progresses. And the last thing I'll mention on that is I think the Supreme Court has given us a hint. I think that it would have been quite easy for the Supreme Court to do what they indicated they were going to do and make a ruling on Section 230. Even if the court found that the ATA was not satisfied, they could have taken it a step further, or they could have started with the affirmative defense and said, we don't even have to get to that. We're choosing to rule on Section 230 that this would be barred for XYZ reason. And they didn't do that. I think that left the door open to say, let's see some more law on this. Let's see how these are completed and see what the future of Section 230 as essentially absolute immunity is going to look at in the anti-terrorism landscape.
Yeah, okay. Well, thank you, Annie Kouba, for that. That's a very valuable aspect of this, is how plaintiffs' lawyers view Tomney. And by the way, could one of you guys, either Will or Annie, tell us what the facts were? Who were the plaintiffs in Tomney and in Tomney, really? It was a consolidated case, so there were a number of plaintiffs, and they were all victims of terrorism or family members of victims of terrorism. Is that right?
That's correct. Yeah, Mr.
Yeah,
Mackie, you want to take this one or have me?
Yeah, essentially, they were relatives, shall we say, of people who were injured, were killed in a terrorist attack. All right, so one was a nightclub, I believe, in Paris. Another one was in Turkey. And this in essence is the question of trying to say the primary liability, remember, was the person that actually, shot the gun, it blew up the bomb. And the secondary liability was you're promoting this, you're distributing this information, which facilitates this activity. And I'd like to focus again on something that Ms. Kouba was talking about, that we got to remember 2333A talks about an act of terrorism, right? It's not the issue about promoting a group, all right? So that's a different issue. It has to say, did this action promote or facilitate an act of terrorism that happened, right? So as opposed to you're waving the flag for ISIS, right? That's a different issue. That's not what the law says. And so that is part of the challenge, is that, under the tort liability, which I think you're more capable of speaking on, the knowledge issue is, did you consciously and culpably participate in a wrong to make it succeed, under the case known as Halverson? So you have to say that, were you doing something to facilitate the act? All right. And I think there was a question that may have been nicely put, which is to say, in terms of Section 230, if if a internet provider, it's essentially called an interactive computer service. Just think it's a provider. If they remove something, right, they are not liable because any action voluntary taken in good faith to restrict access of something that the provider considers obscene, lewd, all this bad stuff. Taking it down, they said, all right, we want to incentivize the providers to stop things from happening without getting liable for it, right? And that's different, as we're talking about, from in any way putting your hand into the content. And that's where I think the point that to be made that both Ms. Paul and Kouba said that in Tame, the Supreme Court was talking about the 2333 aiding and abetting. If a platform consciously and selectively chose to promote the content provided by a particular terrorist group, perhaps it could be said to have culpably assisted in the terrorist group. So that opens it up and says, if you're doing something more than what you're doing for everybody else, but specifically helping them, then you could be held as secondary liable for aiding and assisting. And I would suggest in Section 230, as you were suggesting, that you move from being just a immune publisher to in some way having a hand in content. And if that content, then you no longer have that Section 230 liability.
Right.
And that's where I think the interesting thing was Paul is talking about the auto-generated stuff. I think that's possibly where you're saying, if this didn't exist before and you're putting it on now, then you're publishing that and you're a creator. If I was arguing the other side, I said, no, I'm only reorganizing stuff that's already out there, right? And I'm just packaging it. And so that's where that whole argument comes into. It's, are you creating it? In which case you are the writer, or you have some substantial role in it, or are you just a facilitator?
Right. Okay, let's go to the audience questions, because we have 4, which is a perfect number for the time we have remaining. The first one is it's a fairly long one from one of my friends. It's for Will Mackie. I don't know if you can get to this, Will, by hovering at the bottom, and there's a Q&A button. You're muted. Go ahead.
Yes, I'm looking at it right now. This number 1. Mm-hmm.
Yeah, and while you're looking at that, let me. There are a couple that are directed for Ms. Paul and Ms. Kouba.
Is this from Mr. McCormick you're talking about?
Yeah. Yes, exactly. An anonymous attendee asks, how will Section 230 be considered with respect to the addition of generative AI tools provided by companies on their platforms? Either Katie, Paul, or Annie, Kouba, or both.
I'm happy to take it, or to let Ms. Paul take the first crack, since I've been
Yeah,
talking.
I can give a little bit on that one. And I think that question and the last question about changes to 230 kind of go hand in hand, in that the technology is moving very fast. And if, TTP does a lot of work on influence, and the amount of effort and money being poured into lobbying for these companies to write their own AI bills in the AI race is quite astounding. There's a lot of questions about generative AI, how Section 230 would apply if the content is being created or generated. These are questions that Congress really needs to take on, but unfortunately, it really hinges on reforming the existing laws first, because we are still in a place where we are just now really at the forefront of bipartisan support to address a 30-year-old law, while these companies are trying to slip in and write their own laws for AI to basically create another digital Wild West for themselves. A lot of that has to do with, the copyrighted content. There's a lot of artist stuff about copyrighted music, artist styles being copyrighted for generative AI. These are all major questions, and Congress really needs to tackle the 230 question and the creation of content question, I think, before they deal with this. Whether or not they will is unlikely, but there is currently a bipartisan bill for reforming, well, for sunsetting 230 entirely, or at least creating some sort of reform. That is something to watch. I don't know if it will move very quickly, but one of the things I think is worth keeping in mind for all of these is looking to Europe and the DSA, the Digital Services Act, which was just implemented in August and is extremely strong. And for those who would love to read something very technical, well thought out, but really gets to a lot of the questions about how the companies address illegal or harmful content. Are they doing it quickly enough? Are the tools they say they have for addressing it even reasonable? And unfortunately, because US regulation is moving so slowly, we may need to look to the effectiveness of these kind of programs in Europe to see how the companies are responding or reacting to those new laws.
Right. We have from Paul LeBlanc, who was one of the attendees, we have a more of a statement than a question, but it says both presidents, Trump and Biden, called for changes to 230, but for different reasons. Can Congress in its current state create a new updated 230 to address advancements in technology, or does technology move so quickly that Congress can't keep up? I think back to Senator Hatch's questioning of Mark Zuckerberg. Any comments on that?
Yeah, I'm happy to comment on that.
Sure.
I too remember Senator Hatch's questioning of Mark Zuckerberg, which it comes as a surprise to no one that our current Congress is not the most technologically savvy. I'm of the view that it doesn't necessarily have to be. It needs to try to anticipate future developments as well as it can without keeping such a narrow, antiquated provision in Section 230.
Mhm.
This is not to sound like a broken record, but I think this is again where the civil justice system comes in. Congress, even at its best, moves extremely slowly and is going to be weighed down by the people that are in it and their various knowledge bases. Of course, they're going to be surrounded by experts, we hope, that will help them stay up to date on what they need to draft laws appropriately. But I think keeping the door open to potential future developments in technology, even those we can't quite wrap our minds around yet, is going to be very important. And back to the former question, could help keep AI in that realm as well. That's why the Section 230 immunity clause needs to be updated in general, but also why the definition of publisher likely needs to be re-examined and possibly clarified. However, I think that the civil justice system is a little bit better equipped to handle these evolving technologies. We barely have a grasp on algorithms in the courts and in society at large. And in fact, they're constantly changing and varying. We often refer to the algorithm or the one algorithm at these social media companies, and that's not quite accurate either. In my view, they are a tool. There are some that are of the opinion that algorithms even act as first-party speech on the part of the platforms. I think the same could be true of AI, but even a more compelling reason to say that it's first-party speech because it's learning by interacting with users, yes, but if it ends up providing answers or content on the platform that is created by a tool that is a tool of the platform, that seems to me like the definition of first-party speech. So this is a long-winded way of saying that I do think there's hope for Congress to address this in a way that doesn't require them to be tech savvy and that can bring together some of the interests they all share, things like child safety, anti-terrorism. Both sides of the aisle are going to agree that those are worthy causes. But I think too that there's a parallel track that we should be watching closely proceeding through the civil justice system to see how judges and juries are interpreting social media platforms' actions as we're moving forward.
Yeah, and I referred to ATA as the other terrorist financing because I said that earlier, and that's when I say other, it means to be distinguished from the application of criminal law. One of the nice things about civil law is that it's privately initiated by a private plaintiff typically. And so you don't have to deal with such things as political will within DOJ. We have 10 minutes. Will, can you take on Jim McCormick's question?
Yes,
Describe
I'd be
describe
happy
what it
to.
is.
Sure. In the context here of doing this, I'd like to suggest that the Supreme Court also recognizes, as I said, that they're hardly the most internet savvy people in the world. And I don't think they're going to address 230, or they're not eager to, because their view is that's Congress's job. All right. So we're looking at the text of 230, and it really speaks very clearly about there's no liability for any company that basically removes, filters, screens, disallows content, picks, chooses, analyzes, reorganizes content. They don't want to, I don't believe, get into what that really means. They're going to say, hey, Congress, if you want to do it, you need to do it. And Congress, on the other hand, is sitting, stuck on a 1996 law. So that's why I think they looked at it as the primary issue of 2333 liability. And if it's not there, then we don't have to deal with 230.
230, right.
I see that continuing to go on. Mr. McCormick had a great question when it says, is there a difference between removing content and modifying content? Is there a blurry line between there? And by removing content, are you actually changing, in a sense, the content of the page, right? So let's say you have an ISIS page and you take off one thing, but you leave the rest in there. You take off the beheadings, but not the promotional stuff. Because yes, in a sense, you are changing the nature of that website, but 230 allows you to remove something, right? Or not. But you cannot change the content. Like you can't go in and edit and blur out somebody's face while the beheading goes on or whatever. Because now you're actually creating content. So as it stands, it is kind of blurry because, like, if you're talking about a page and it's like Ms. Paul was putting up there and you're taking off 3 lines, but you're leaving the rest. Yeah, to an extent, you are kind of editing that.
Yeah.
But 230 allows them to do that.
Right.
And it basically says, yep, you are acting as an editor, but we're carving that out for you.
Right.
Okay. And as long as that exists, your options are take it down, not the whole thing. You can take the whole thing down or take a part of it down or leave it.
Yeah.
You just can't change the content. So I think it is kind of a blurry line. And you are, in a sense, the question Mr. McCormick says, by taking out one portion, are you kind of cleaning up the rest and licking the ISIS page to look better? Well, yes, but 230 allows you to do that as it stands.
Okay. Katie Paul, I'll give you the last audience question because it cries out for what you said in your presentation, and I'll just read it to you. Could you please explain again how Facebook allows the selling of artifacts when it is considered a war crime to sell items of this nature from a terror nation and or items from a nation after war? Or did I get the details wrong for my question? If it is a war crime, how can Facebook get around this aspect when it is clear that the items are being sold on their platform with pictures? Could you elaborate? Are items being sold on the Facebook marketplace?
Items are being sold both on the Facebook marketplace, but the ones that we see trafficked by terrorists are largely in private Facebook groups. Some of these are buy and sell groups. Some of the items are still in the ground, like mosaics, when they are offered for sale. It is a war crime. One of the issues is that Facebook would need to be prosecuted for that. I don't think the ICC is going to bring a war crime for that anytime soon, given what we're seeing happening in Ukraine and some of the other major cases. That said, Facebook benefits from the fact that this is largely in countries that are in crisis or conflict, that are resource strapped and don't have the bandwidth or knowledge to be able to bring a case in a U.S. court or in an international court for war crimes. So, there really are a lot of questions about this issue. Facebook is the facilitator of this particular crime. This scale and in many cases this reach is simply just not possible in human to human contact when it comes to trafficking these types of items. And it's not, antiquities are just one of the many war crimes that are trafficked. They're facilitated through the platform. It's a massive growing problem. Even despite their policy, we see 5 times as many groups. One of the 500 some groups I'm monitoring has nearly 1 million members. And the scale is quite shocking. There are still a lot of questions. Even Egypt's parliament at one point had addressed whether or not they could take on Facebook or create a parliamentary motion that would affect Facebook, the company, because it continued to fail to respond to any of their requests about the trafficked sarcophagi that were on the platform. And ultimately, because it was an American company, they realized they had no leverage. This was like 2016, 2017. There's quite a bit of Egyptian media about it. But that's where these companies, being American companies, have the benefit of being here and the protections with the lack of regulation. And unfortunately, until that changes, we're going to see these types of crimes and the exploitation of people in the developing world and governments in the developing world continue to suffer at the hands of these major corporations.
Yeah.
And I would echo on that to say, let's think about this, that if Facebook Marketplace or whatever is allowing bidding on items or something like that, I think that transports it into facilitating. Right, it's not public. You're actually helping something. I think you could. That's not a Section 230 issue. That's a aiding and assisting. That's a facilitating issue. If they had a GoFundMe page for ISIS and they're collecting money, I mean that's material support. And your issue about sanctions, that's another way. If you look at services provided that falls under a different law, then yes. That does it. That's not a Section 230 issue. So that's what we do. We try to use the laws that we have right now to address this bad conduct.
Right. And just very briefly, there is actual support for exactly, which I'm sure you're aware of, Mr. Mackie, exactly what you're saying in those kinds of cases surviving 230. The NRA Apple case they were found liable for illegal gambling on their platforms because they were facilitating that illegal gambling by selling chips. I think there are a lot of parallels to be made there in the anti-terrorism space, certainly outside of streaming without knocking streaming out of the possibility of still being substantial assistance to terrorist activity.
Okay. Well, we're out of time, but let me be the first to thank all of our panelists, Katie, Paul, Will, Mackie, and Annie Kouba, and ask John, if he's still on the line, if he has any parting words.
He must have left a long time
ago. Must have left, yeah. Okay. Well, this was, I was very happy to do this because it was actually introduced at the ATA event that we did a couple months ago. And some audience member actually asked whether we could do an event on social media liability for terrorism. And so that's what culminated in this event. And I will say, as an observation, that when I was out seeking panelists, I was fairly shocked by the number of so-called experts who believe that the only solution to any of the internet problems right now is to let the marketplace decide. In other words, they don't believe in any regulation of the internet. They think it ought to stay unregulated, and I certainly don't feel that way, and I don't think our panelists would feel that way. So with that, to the extent we didn't get into all the audience questions, I will respond, or I'll direct the question to the right person. I think there are two that we didn't get to. But thanks, you guys, for this. And on behalf of Lorenzo Bedino, who is our executive director here at GW, I want to say thank you for another successful event.
And thanks to all the attendees. We very much appreciate your interest.
Yes. Yes.
Very much.
Okay. All right. Thanks, guys.
Thank you.